We can't guarantee proper hybridity, so what we're offering is an ability to watch the stream, but not full engagement with questions and answers. Unless we're really stuck in the zone. Our focus is on you who have been able to make it. Thank you for that, and I hope you're looking forward to the dinner afterwards. We'll do introductions as we go through. I think I know many of you in the room, but I have the privilege of hosting this event, so my name is Clement, if you don't know me already. The committee that organises this is made up of some wonderful people, and it's assisted by us as well. But in particular, today behind me is Mark D'Souza. We have giving one of the things today, Richard from Tolley, and many of you will know the excellent Jarvis here, who's also speaking in the last slot today. There'll be some further administrative arrangements along as we go, but considering the time, I'd like to just get started. I would note there are teas and coffees available outside, as you saw. If anyone asks, we did not bring any tea or coffee or anything to eat into this room. Okay. There are bathrooms just around on the outside. Fire exits are marked. Essentially, you can go around either way. This is the old city hall, so don't try and go to that. So the exits are primarily out through that direction. So our first paper today is called Rethinking the Person in Non-Focal Offences. We're very lucky to have Rachel with us today. Rachel was with us before moving over to Cambridge, where she got Paul. And the comment is being given by David Fulier, who's at Free Game Building.
Thanks, Matt. Good afternoon. Real pleasure for you to kick off today's slide seminar with a paper on a topic I have to say I spent a bit of time thinking about a few years ago and have spoken about before, but not many. But it went on this one benefit. So this is the law governing widely criticised. I'm sure I need not list the litany of complaints to this group. And so whilst much can and has been said against the current law, my focus is on a relatively narrow point, and with one or two notable exceptions, it's I think a widely overlooked deficiency in the way that we understand and construct the very object that these offences are designed to protect, that is to say, the body. In short, the problem I'm concerned with is this. If Richard comes along with a crowbar and intentionally breaks my leg, he'll be liable for offence under the OPA, likely causing grievous bodily harm with intent. But if he attacks my friend Maggie instead and breaks her prosthetic leg or her wheelchair and causes no further or additional damage, the only offence against the person for which he can be held liable is battery. With respect to the damage to her prosthetic leg or wheelchair, Richard would be liable for criminal damage. Assuming, certainly in the case of a prosthetic limb, that Richard knew Maggie's leg was artificial, he can't even be held liable for an attempted ABH or GBH offence, as he hasn't intended to damage anything that criminal law would recognise as constituting bodily harm. But the offences of battery and criminal damage do little, I would argue, to capture the true nature and extent of Richard's conduct in launching a violent attack on Maggie's physical and bodily integrity, and nor does it really capture the true nature of the harm that she suffers as a result. I argue, or at least I would like to argue, that the law of the offences against the person should adopt a broader understanding of body, one that recognises mobility aids, prosthetics, and perhaps some assistive devices as part of the person rather than property which belongs to them. This extension of our understanding of the body might seem controversial, but with a little bit of working through, I hope to show that it's feasible and appropriate as a matter of principle to extend the law in this way. For the sake of time today, I'll just take as a starting assumption the position that the mere touching of a mobility aid, prosthetic or chair, at least when it's in use, constitutes a battery. I can explain why I take that position in the Q&A if you like, but I think this is a relatively orthodox extension of the current law. Causing damage to a wheelchair or a prosthetic does not, however, constitute bodily harm on the law as it currently stands. I assume that I will have some work to do to persuade anyone that it can to do so on an extended interpretation. So we might begin by noting that the courts have interpreted this notion of bodily harm as encompassing the cutting of hair, the transmission of disease, recognised mental health conditions. These decisions all arguably extend the scope of the offences beyond the intentions of the Victorian legislature. Why not further extend the notion of bodily harm to capture my cases too, so as to better reflect the nature of the harm experienced by Maggie and people like her, and the important features of the defendant's wrongdoing. To recognise the damage to her leg as grievous bodily harm, we would need to extend our understanding of what constitutes bodily harm, and this would necessitate a disruption of the traditional biological boundaries of the body in law and indeed our imagination, to sort of more accurately recognise or encompass a greater range of embodied subject under the law. There are, I think, three immediate objections that might be made to my argument. It might be said that such a classification would be inappropriate because the victim doesn't suffer any pain or any threat to life, or because the mobility aid can be easily and quickly replaced. Unlike the body, it's essentially fungible. We can't grade, thirdly, levels of severity of injury, at least not straightforwardly, once we move away from traditional understandings of bodily harm. But I think these are relatively minor objections, they're not particularly persuasive to me, at least. The House of Lords in DPP and Smith in 1961 already determined that harm need not be objectively dangerous or pose a risk to life in order to amount even to grievous bodily harm. Medical treatment isn't a necessary precondition for any harm, injury, or damage to constitute ABH or perhaps even GBH. In the other DPP and Smith, the divisional court held that cutting hair can constitute actual bodily harm, so pain clearly isn't a requirement either. On the second minor objection, the fact that one artificial limb or wheelchair is ultimately replaced with another almost identical need not pose a barrier to recognising liability for ABH or GBH. Skin and blood cells regenerate, diseases can be treated, an individual can suffer an injury recognised in law as ABH or GBH, and there need not be any lasting physical legacy of that injury once it's healed. Moreover, the objection rests on the false premise that mobility aids are easily replaced. And yet, in reality, individuals may be forced to wait for months for a replacement prosthetic limb or wheelchair and experience significant impact upon their mobility, day-to-day activities, and mental and physical health in the meantime. Whilst pain and threat to life no doubt inform the distinction between assault and ABH on the one hand and ABH and GBH on the other, these features are certainly not necessary conditions of bodily harm, and we can also draw distinctions between different legal categories of injury with reference to the extent of any loss or diminution in functionality or mobility, so we don't need to have some kind of pain or danger or medical treatment in order to classify injury according to severity or damage to prosthesis and mobility. This does leave then the most significant objection to my argument. What's the positive reason for extending the scope of the law in this way? Perhaps my cases don't involve damage to the body, that's just a simple fact. They're accurately classified as criminal damage. The wheelchair or the prosthetic limb simply is property. This narrow definition of the body makes a claim of objective fact, but of course it is an area of some philosophical debate. Phenomenological understandings of the body focus on what Sean Ass, is how I pronounce his name, I feel like I'm describes two-way transparency within phenomenological understandings of the body. The body is the interface between the self and the world. We have a sense of where we end and where everything else begins. I can, without really thinking about it, move my hands, and certainly when I move them to the table, I am directly experiencing the world around me. When I feel the table is, I'd said cold, damp, hard, but it's actually quite warm and soft. I perceive the world around me. I'm directly processing sensory feedback from the world in an unmediated sense. Research suggests that one's sense of self can extend through and into a prosthetic or assistive device. It's not necessarily something people use in order to obtain sensorial feedback. It might become like my hand, the sort of embodied recipient of that feedback itself, a point of interface between you and everything else in the world that isn't you. In his seminal work on phenomenology, Maurice Merleau-Ponty described the way that a proficient user of a cane perceives the world with and through the cane. The body of the user, through his sensorial perception, extends through and into the cane. What was once previously a mere object becomes an interface between that person and the world. It becomes drawn into their understanding of their own body. Miko Kuma describes how when a lover of a person in a wheelchair touches the chair, she shivers as if the flesh of the person was caressed, and in a sense, the person was touched. The lover touched the wheelchair as an extension of the person. Such understandings of the body perhaps better describe the experience of certainly some, if not perhaps many of those who use mobility aids. Psychologist Craig Murray has noted that this concept of embodiment certainly reflects the goal of many who work in the rehabilitation field, aiming to transform a prosthetic limb from an inert supplement into an extracorporeal structure into a corporeal structure. And there is seemingly an increasing amount of empirical research that suggests users of prostheses do indeed embody their prosthesis. They incorporate it into their bodily space so that it's included into sort of the way they understand what's them and what is the rest of the world. It's experienced, integrated into their own body image. There's some research that suggests that you need to have some kind of top-down conception of what a body image is, so something which is very different to kind of a typical body structure that might not be so readily incorporated into someone's body image or body scheme. But there's some dispute in the literature so far as I understand it. But there is some empirical research to suggest that users of mobility aids do embody them, do kind of see them as part of their own body image. And this is happening in a neurological. The assumption then underlying the current law of ADH and GBH is certainly open to challenge on this kind of account. If this provides a plausible alternative way of understanding the boundaries of the body, then we have a real debate on our hands. We shouldn't simply assume that ADH and GBH cannot extend to prosthetics and mobility aids only because that's what we've always known and always done, and our sort of imagination of the paradigm subject under the law is an able-bodied individual who has no need for a wheelchair or prosthetic limb. Now, I don't wish to suggest that users of mobility aids are a homogenous group, that everyone who uses a mobility aid experiences their prosthetic or their wheelchair in this sort of manner. Research indeed suggests this is far from the case. But I think that for these purposes, it's sufficient to note that this seemingly uncontroversial claim that a prosthetic could never possibly constitute damage to the body could fail spectacularly in capturing the nature of the harm as it's experienced by the victim of a violent attack, which does result in damage to a level of the chair. If the harm can and perhaps should be understood as harm to the body, what about the defendant's wrong? Where the defendant kicks the victim's leg, artificial or otherwise, or takes a crowbar to the wheels of the chair, it seems plausible to say that this is a wrong against some kind of bodily interest rather than simply a property interest. The defendant is attacking the victim's person, something that he practically identifies with the victim and their bodily space, at least broadly defined. It's a much more serious attack than the offence of battery could ever hope to reflect, and it doesn't seem unreasonable, I think, to identify this as something that's, certainly from the defendant's perspective, morally significant or distinct to simply kind of taking the key to someone's car and striking up a lap and being frustrated with a friend or colleague. There are three, however, major challenges worthy of detailed consideration. The first is what I like to call the glasses question. I think this is the glasses question. What counts? Does it extend to glasses, to hearing aids, to guide dogs, to adaptive cars? What about our mobile phones or Apple watches? I think this objection is perhaps less troubling than it might initially seem, at least if we take an embodiment account to explaining why we would take this extended view. The proposal isn't that we reimagine the body based on some kind of functionality analysis, or on the premise that some forms of property are particularly valuable or meaningful to us in a deep and profound sense. If the extended interpretation of the body is based on the experience of the embodied person, on the fact that the prosthetic or mobility aid is integrated into their sense of self, their body image, becomes the interface between what they consider to be themselves and everything else, then this worry might not be so troubling. we're looking to identify those mobility aids and prostheses, assistive devices, which are themselves something through and with which the victim experiences the world beyond themselves, rather than simply an item that the victim experiences being separate and distinct to them. We might then resist the glasses explosion. It doesn't seem plausible that the world, certainly at least in the world as it is now, that a mobile phone or a car could constitute part of the person under this sort of framework. The suggestion that a guide dog might fall within the framework should also be rejected on additional grounds. The guide dog's a sentient being. It can't simply be subsumed within and integrated into the identity of another person or being. Glasses and hearing aids.
Sorry, if I can handle it. Don't worry, it's fine.
Glasses and hearing aids are a little more difficult, I think. But when the victim truly embodies their glasses or their hearing aids, if indeed that does occur in the sense that I've set out today, I'm not sure I see any great difficulty in conceding that damage to such things might constitute ABH or GBH if, in all circumstances, the damage caused reaches a threshold level of severity sufficient for ABH or GBH. Given their ready replaceability, glasses are perhaps unlikely to reach this threshold, something like a cochlear implant, perhaps not, perhaps that more readily reaches a level of severity if it's hard to replace. Moreover, I think given the proximity of glasses and hearing aids to the face, a situation in which an individual does not sustain other personal injuries, but their glasses or hearing aid is damaged, is perhaps unlikely. Of course, if the victim wasn't wearing the glasses or hearing aid at the particular point in time, then damage to the device without injury to the person traditionally conceived becomes more readily conceivable. And this, of course, this leads me on then to the second difficulty. Does it matter whether the aid or the prosthetic is in use, attached to the biological body, or out of use and unattached? If the basis for reconceptualizing the body is grounded in embodiment, then my simple answer is, to be honest, I don't know. I would think it depends on how users of mobility aids and assistive devices relate to and experience them when they're not in use. And of course, this won't be a monolithic experience, I imagine. I've not been able to find much of any research on the point, but ultimately I don't think the gap in understanding prevents us from reaching a decision about how the law should construct these offences. Because as criminal lawyers, we care about fair notice, fair warning, as much as we do fair labelling. When we use the power of the state to express through a highly stigmatic criminal conviction moral condemnation of the defendant, it's important to ensure not only that the offence label accurately communicates, at least in broad terms, the nature and gravity of the defendant's wrongdoing, but it's also important to ensure that individuals have reasonable warning of their potential liability for an offence of this kind, particularly when we're talking about a distinction, I think, between offences against the person and offences against property. When a mobility aid is in use, the defendant is, I think, on notice that a potential ABH or GBH offence might be committed, in the sense that he should, and I suspect often would, integrate the device or the mobility aid, the prosthesis, into his own understanding of the victim's person or self. Not only is the harm suffered by the victim bodily in some extended sense, but the defendant's wrong is more straightforwardly a wrong against that person, because he too has or should have integrated the mobility aid into his understanding of the identity of the individual in front of him. But when the aid is not in use, unless the defendant intentionally damages it, fully aware of its use and significance, in order to reduce or impair the victim's mobility, then it seems to me plausible that liability wouldn't be appropriate. And of course, but given the general way in which these offences are constructed, and the fact that any extension to the current law can only be operationalised through a reinterpretation of bodily harm within the OAPA, it's unreasonable, it's impossible to suggest that the courts could construct or reinterpret the current law in such a way that could make a defendant liable for ABH or GBH for damaging an out-of-use aid, if and only if he's aware of its significance and it's intended and intends by damaging it to restrict mobility and functionality, assuming indeed that it is embodied in a relevant way. And so I think if the current understanding of body within bodily harm within the OAPA is to be reinterpreted if we're to extend the law within its current framework. I think fair warning would demand the retention of an in-use, out-of-use distinction, and so perhaps we can set to one side the big question mark in terms of how embodiment works in that particular context. Finally, we must also grapple with how the law should deal with a situation where a particular victim doesn't experience the damage as affecting the person, but rather her property. We have two options. We could be over-inclusive, recognise it as an offence against the person anyway, or we could vest a bodily harm criminal damage distinction in the victim's subjective experience of mobility aid. I'm inclined ultimately to prefer the over-inclusive approach. It avoids a situation where you're treating two defendants quite differently based on a sort of relatively on a factor that's difficult to observe through any sort of external perception. And you wouldn't have to cross-examine a complainant on the stand to try and figure out whether they did in fact embody their mobility aid. I think that would possibly be a little unedifying and perhaps unnecessary. We should be sceptical, I think, of any suggestion that CPS discretion could be used to make the charging decision on that borderline question. It's not clear to me how they should exercise such discretion. An over-inclusive approach does risk, it's true, seemingly endorsing the idea that there's one right way of experiencing mobility aid, and this is something we should be wary of. But whether or not someone does embody their mobility aid could depend, at least in part, on contextual factors like how long they've been using it, how much support they've received in that process. We might see a stratification of those who do and do not embody their mobility aids across lines of socio-economic or other vectors of privilege or disadvantage. And we might worry that treating the defendant's actions less seriously as a matter of law by criminal damage rather than an offence against the person risks compounding that inequality or lack of privilege that might act as the barrier to embodiment in the first place. Recognising all mobility aids as part of a person as a matter of law might have the beneficial effect of increasing respect and dignity for those who use them, and in turn, therefore, help combat barriers to embodiment and integration. What time do we start, Matt? So, 2 minutes. Good, excellent. So there we are. A combination of embodiment analysis and rule of law considerations might allow for a robust, workable, extended definition of the body. But it does rest, at least in part, on the possibility that this concept of embodiment provides a positive reason, a workable, a robust basis for such an expansion of the body beyond its traditional biological borders. And this is where the paper becomes more obviously a work in progress. Because I've recently become a little more concerned about whether this embodiment account is capable of doing the work I might need it to do. Sean Aspect in his work has argued that embodiment accounts are both under and over-inclusive. You might embody a tool like a pen. I don't really think about what I'm doing with it when I write with it, and I can certainly obtain some kind of sensorial feedback through it. Don't know if anyone's ever seen the rubber hand illusion. You can look at it on YouTube, but it probably provides a good example of a scenario where someone embodies a rubber hand and flinches, thinking that it's about to be hit by a hammer. But I don't think anybody would plausibly suggest that damage to the rubber hand ought to constitute actual or grievous bodily harm. On the other hand, you don't really embody your kidney or your liver. You don't really experience it or think about it, gain any kind of sensory feedback through it. So for any phenomenological account of the body is immediately open to question, and beyond just straightforward over and under inclusivity, because it is, as he suggests, realised in fragile and faulty mechanisms like the brain. When something goes wrong in the brain or in your psychology, then the analysis might produce a wrong answer. Now, for him, the conclusion is not to revert to a traditional narrow account, and I think this must be correct. He largely takes as axiomatic, as I read in that, the argument that any account which excludes a prosthesis is just axiomatically wrong and is under-inclusive. But he also makes the argument, and I won't go into the scientific literature, it's on the list of things to really get my head around properly. But it seems plausible based on what I've read thus far that biological definitions of bodily boundaries struggle more than we might like to admit to define the parameters of what constitutes one organism or another. You just need to think about sort of immunology and the rejection of your own sort of cells, your own organs, to sort of begin to see where some of those problems might arise. And so I don't think that we as lawyers can just default to an assumption that the science can help us present some objective, neat, clean definition of what constitutes the body versus property or the rest of the world, and reject the embodiment analysis out of hand. So for Sean Astor, his approach is to say, well, look, the question of what we should treat as the bodily part, to quote him, is inseparable from the question of why the body deserves special protection. He thinks it's a distinctively moral and political question rather than a scientific or a psychological one. He offers a preliminary account of what an understanding and conception of the body might look like on such a programmatic argument. It's necessarily preliminary, but a quality of function seems to play an important role in his argument. Equality does a lot of work, equality for people with disabilities, disabled people, does a lot of work in providing a reason to expand the definition, but it's the emphasis on function, equality of function, that does the work in drawing the boundaries around what would constitute the body and what would constitute property on his theory. In addition to a requirement that the prosthesis or device isn't easily replaceable. My worry here is whilst there's much in his account which is helpful, a return to a focus on function risks reopening Pandora's box. Why not phones or cars or Apple Watches? As argues that, well, you don't need a phone or a car to be functionally equal in society. It might be helpful, it might be useful, but it's not a core condition of basic functional equality. There are workarounds, public transport, alternative means of communication. Phones are easily replaceable in addition. But I'm not so sure about this. If you live in a very rural area with limited access to public transport and public libraries, and having just had Stagecoach threaten to remove our buses, I feel like I've got a new appreciation for the reality of this. It doesn't seem to me so obvious that for everybody, a car might not be necessary to be basically functional in society if there is no bus available to you. And given the increasing range of online-only service provision that demands a laptop or a mobile phone, it isn't obvious to me either that a basic equality of functionality doesn't necessitate an internet connection. And if you can't afford a laptop and a monthly Wi-Fi bill, your mobile phone might be the only thing you've got. Sure, phones are easily replaceable, but only if you've got the money to replace it, a point which an equality-based account should, I think, give greater consideration. So I have some worries that on the one decent programmatic, or the one thought through programmatic account of what the body might be, based on a moral and political understanding of why we value the body, doesn't do a particularly plausible job of drawing the boundaries in the right place. Where does that leave me? Worried about whether or not I can escape a functionality assessment and what that might mean, sort of glasses question. Wondering whether an embodiment account can somehow survive the criticisms that has been levied against it. Whether a different kind of purposive moral account of the body can be constructed, which doesn't fall foul of the glasses question. Whether there's some kind of way I can draw from both to create a nicer hybrid, which might help me find a way through the trees. I don't know the answers to these questions yet, so if you ask me, then that's the answer. I'm very happy to answer all other questions on the paper in the Q&A, and I would be extremely keen to harvest or to open a discussion about any aspect of the work that I've been thinking about for probably too long. But thank you very much for your time, and I look forward to commenting on questions.
Few days and I know that it is, as Rachel pointed out, a work in progress. So I want to offer some hopefully constructive thoughts on where the argument seems to me at the moment to run into some trouble, and perhaps what might be done about it. Although on that topic, obviously, I'll be better at criticism than constructive proposals. So the essence of the argument, as I understand it, is that we should recognise mobility aids, possibly other aids, as being part of the body for the purposes of the offences against the person, because as a matter of fair labelling, it better characterises both the nature of the harm suffered by the victim and indeed the wrong committed by the defendant than criminal damage. I think Rachel's very adept, if I may say so, at countering the objections that might arise, particularly the points about lack of pain, but of course cutting hair is ADH, and the mobility aid is an object which can be replaced, unlike the body, and she's dealt with that. Of course, it's not necessarily that easily replaceable. But to advocate a reclassification in criminal law successfully, it seems to me that there needs to be, first of all, a sufficiently watertight positive argument or reason for moving from the current position before you get to demolishing the objections that might arise. So essentially, you need to get over the threshold as a first step of reversing the presumption that the status quo applies. And the status quo, I think we can all agree, seems to be at the moment, body means the biological or the organic body for the purpose of bodily harm. And that includes the brain and the nervous system. That on mental illness now counts as bodily harm, but nonetheless it's still to do with the brain and the nervous system, and that's all part of the biological body. At the moment, it seems to be in Rachel's argument, that positive reason that we need seems to rest pretty much entirely, I think, on the embodiment theory. And if that's right, then we need either that, or if there's a problem with it, then something else to take its place to provide that positive argument for reclassification before we get to objections. And the reason I say, and I think I've seen Rachel nodding, so she clearly agrees, but why it rests entirely on the embodiment theory. Well, she's made very clear it's not about an analysis of functionality or of value of the particular property. It's not, sorry, it's about the fact that the extension of the body is based on the experience of the embodied person, such that they integrate it into their sense of person or their sense of self. And it seems to me that must be right, because if it's, it can't merely be about functionality. It needs to be that the mobility aid in question is seen as part of the body, not simply that the victim is particularly vulnerable, or that the aid is particularly valuable for the continued functionality of the body. Because otherwise, as Rachel's pointed out, that would include within the definition things that we can't really sensibly say as a matter of fair labelling our body parts, like smartphones, no matter how lost we'd be without them, or like adapted cars. So that can't be the positive reason for reclassification. And neither can it be the reason, I know Rachel hasn't expanded on this, but the reason why it's battery, and I think that's right within the current law, it's battery to touch somebody's, say, wheelchair or prosthetic leg without touching their biological body. The reason for that seems to be for the same reason that it's battery to touch somebody's clothing that they're wearing. It seems to be temporary proximity to or contact with the body. And that's not enough either, because that will apply to clothing, and clothing's not enough. So it's about being seen properly as part of the body. Right, so it comes down to embodiment, which is very much not my area of law, and it's the first time I read about it, and it's absolutely fascinating. And I'd be really interested to do more research about it if time permits. But it seems to me within this argument that it's potentially problematic for the purpose of criminal law and from the perspective of a criminal lawyer, because we're talking about how the user of a mobility aid can perceive the aid as part of their body, essentially, through which they perceive the outside world, as opposed to a thing which they perceive. But Also, Rachel's told us, and perhaps unsurprisingly, research shows that such users are a heterogeneous group, like any group really, who do not all experience their prosthesis or mobility aids in this way. So, arguably, for the purposes of perfect fair labelling, as far as the harm to the victim is concerned, damage to a mobility aid or a prosthesis should be damage to the body if you do so perceive it, and shouldn't be body harm if you don't so perceive it as the victim. But of course that poses a problem because it makes the nature of the offence contingent on the experience of the victim. And as criminal lawyers, we know, and Rachel recognises that it can't be, because it would be contrary to legal certainty and to fair notice, quite apart from creating significant practical difficulties, which the victim essentially would have to submit to what would come to hostile psychoanalysis in cross-examination on how they perceive their own body, and that's plainly not a good idea. So Rachel proposes instead taking the reclusive approach. So essentially we should assume the embodiment theory to apply, even if the individual victim doesn't perceive their body to encompass, say, their wheelchair. So we should essentially deem it that they do so, and perhaps also that they should do so, which creates potentially different problems. But the problem I want to focus on is that isn't it the case that we can't really be consciously over-inclusive in criminal law, because we can't err on the side of over-criminalisation. And if the need for legal certainty demands that all cases fall a priori on one side or the other of the line, even though in practice we know that they're going to fall on both sides, mustn't there surely be under-criminalisation? Because isn't it a fundamental principle that really doubts should be given to defendants, and fairness to defendants can't be overridden in pursuit of other aims. It's not fairness to defendants isn't an aim, it's a constraint, and you can't override it to get somewhere even if you want to get there. And so wouldn't it be unfair to a defendant to be criminalised on the basis of the embodiment theory if the empirical reality is that it may or may not apply in his case? So, in an attempt to offer some constructive musings as well as critical ones, I wonder whether, for starters, whilst Rachel works out the wider theory, there might be a narrower test to be advocated without having the burden of proof, or rather a narrower reclassification, without having essentially the burden of proof of adducing empirical phenomenological evidence as to what victims, who are never going to be all victims, may perceive. And the narrower argument I have in mind is perhaps applying this argument only to prosthetics, so essentially something which literally takes the place of the part of a part of the body in all senses, not just in function, but in location, in shape, and any other attribute you can think of. So essentially like a prosthetic leg or an artificial eye, or something like that. There perhaps one could say that the courts should recognise that this objectively is a part of your body without having to prove or to assume individual perception. And you may not have been born with it, but that applies to transplanted organs as well. So that's not a reason why it can't be part of your body. And in all other senses, it is literally a part of your body. It would mean drawing a distinction between most obviously a wheelchair and a prosthetic leg, because a prosthetic leg is an artificial part of the body which takes the literal place of a missing part. Whereas a wheelchair, in this sense, like glasses or hearing aids, I'm not suggesting it's not perhaps more important, but it is a separate aid which supports or replaces only the function of the body in that sense. And I can see that other problems may arise, like drawing a principled moral distinction between the two. but it would at least achieve legal certainty, and it would avoid the problem of over-inclusive criminalisation, and not least, for instance, because the degree to which users of wheelchairs or canes or other such devices are reliant on them can vary widely. And perhaps it wouldn't be fair for a defendant to be guilty of bodily harm, say, if he damages the wheelchair of someone who's just using it for 2 days because they've got a sprained ankle. And that problem is not going to arise with prosthetics because they can only be there because there's a body part permanently missing. So I end with this thought. I wonder whether if the line was drawn at prosthetics only, that could be something which the Supreme Court would countenance extending without legislative intervention, given that in Ireland which you all will know, extended the definition of body harm to mental illness. The House of Lords made very clear that the interpretation of the OADA has nothing to do with the intention of the 19th century Parliament, and to sort of justify my role as a practitioner talking in this seminar, I'll just leave you with a quote. They said this: "I would go further and point out that, although out of considerations of piety, we frequently refer to the actual intention of the draftsman, the correct approach is simply to consider whether the words of the Act of 1861, considered in the light of contemporary knowledge, cover, in that case, recognisable psychiatric injury, but really whatever we wanted to cover. The statute must be interpreted in the light of the best current scientific appreciation, again, in that case, of the link between the body and psychiatric injury. But that might perhaps be used to include in today's society and understanding.
Right, well, the view is that we can move straight to questions. So please indicate to me in traditional horse trading way by an appropriate signal, and I will try to get a list. When you introduce yourself, please say who you are and where you come from very quickly. Please keep questions